take your seats. Caribbean Court of Justice, Original Jurisdiction, hearing of the advisory request number AOOJ2019-001, in the matter of a request for an advisory opinion by the Caribbean community. Can we have the appearances for the court again, please? Thank you.
May it please your honors, I am Cornita Babshefer, and I appear on behalf of the Caribbean community in association with Mr. O'Neill Francis.
May it please your honors, I appear on behalf of the state of Barbados with Ms. Sandra Rollins.
May it please your honors, I am David Berry, and I appear on behalf of the Faculty of Law, University of West Indies Cave Hill campus, with Westman James and Nicole Foster.
May it please your honor, Carlo Brooks Harris, with me, Dr. Vanessa Moore, here on behalf of the state of Antigua.
Your Honor, Simone Williams Thompson, appearing on behalf of the Federation. With me is Federation of St. Kitts and Nevis. With me is Mrs. Tashnapala Williams.
Ms. Forrester, could you take your seat, please? Ms. Forrester, could you announce your appearance?
May it please your honor, Dear Forrester, appearing on behalf of the state of Grenada.
Thank you.
She announced her appearance. She announced her appearance.
Okay, yes. Good morning to council.
Of course.
We still don't have that representative from Mona. Okay, so the list, the order this morning in which we would hear council is Dr. Moore from Antigua and Barbuda, and then Mrs. Brathwaite, then Ms. Forrester, then Ms. Bullen Thompson, and then Dr. Babshefer. So,
What about Yui Cable?
but we heard Yui Cable yesterday afternoon.
Oh, I saw them here. I saw them here. I saw them in what we were sent. Oh.
Dr. Moore? Now, you don't need to exhaust your time if you feel that there is enough that has been said on the various points.
But you might be able to say something about that opt-out from 2006, which still seems to be in place.
But if you can't, do not create.
I can't.
I thought so.
Just a correction, I'm Carlo Brooks Harris, and not Dr. Moore.
Ah, I see. I'm sorry. Okay.
Dr. Moore is sitting there.
You are Dr. Moore.
Yes.
I see. Okay. Okay.
If it pleases the court, it is respectfully submitted that there appears to be a general consensus that a member state can lawfully opt out of a decision
of the conference once it does not prejudice the objectives of the treaty. The state of Antigua and Barbuda accepts the submissions of St. Kitts and Nevis, Grenada, and the Amicus Curiae of the University of the West Indies that Article 27.4 of the Revised Treaty is silent in respect as to what are the consequences when a member state opts out from an obligation arising from the decision of the conference. Consequently, it is accepted that the true interpretation of Article 27.4 suggests that a member state who opts out from an obligation arising from the decision of the conference should be able to derive the benefits as the other member states are bound by the obligations of the decision of the conference. However, it is respectfully submitted, notwithstanding this foregoing, that this does not exclude the point that the principle of non-reciprocity should not apply where a member state has been granted an opt-out of a decision of the conference pursuant to Article 46 of the Revised Treaty. It is further submitted that the Article 27.4 is prefaced by the words subject to the agreement of the conference. And this denotes that a member state's decision to opt out of the obligation arising from the decision of the conference is contingent on the agreement. It therefore follows that the conference...
Is that agreement capable of going beyond simply determining whether you are going to be permitted to opt out or not, but also embracing issues of the conditionalities on which you are allowed to opt out? What's your view on that?
I will get there, Your Honor. It therefore follows that the conference in the agreement should set out guidelines and/or framework which would include the applicability or the non-applicability of the principle of the non-reciprocity for all member states as it relates to the member state who opts out of an obligation arising from the decision of the conference. This will result in member state having a clearer understanding the extent of their obligation of the decision of the conference when a member state opts out from an obligation arising from the decision. In other words, the conference should have the flexibility to suspend the opting out member states' rights and benefits in relation to the decision.
Provided, of course, that whatever the conference agrees does not prejudice the fundamental objectives of the community.
That is indeed correct, Your Honor. So it's further submitted that this approach may be the best way forward whenever Article 27.4 is being invoked.
But then what should be the default position? Suppose nobody adverts to the conference. The agreement does not advert to any such details.
Well, the default position is that if it doesn't, then we go back to 27.4, which is silent. The true interpretation of 27.4 does not allow for the member states to benefit, the opting out member state to still benefit under the decision.
That's your view?
A true interpretation of Article 27.4 would allow that.
The amicus curiae had some pointed arguments there which lead to the opposite conclusion. You heard them. What do you say to that?
If Your Honor could point out, I'm not sure what...
The proliferation of derogation denial, stepping away from the treaty obligations, etc., is fractious.
And fraught.
Well, the position that I'm seeing, haven't construed, looking at 27.4, it doesn't provide a mechanism as to what will happen when a member state opt out. So I submit that there is no reason, there is no need to imply, there is no room to imply that the non-reciprocity rule will apply.
But I guess your solution is that in all instances, it should be determined at the level of conference.
That's indeed true, Your Honor. That's my position.
There is, I think, an extension of that proposition which has occurred to me, just among a number of other thoughts, which is that it could be required as a matter of practice and indicated when a country is seeking to opt out, that the country must indicate in its application, in its seeking the agreement of conference, the country must indicate whether it is prepared to be treated in a reciprocal manner or not.
And I will concur with that suggestion, Your Honor.
I suppose the best person to ask this would be Dr. Schaefer, and we certainly will. I don't know if you have any first-hand knowledge of how these things operate in practice, such that, for example, if a state, Antigua and Barbuda, knows that, okay, this is on the agenda to enlarge in these classes, this class, and the state has a position on this, that, look, we don't want to veto this decision, but equally, we would like to opt out of the obligations. One would imagine that the state would voice those reservations, and I speak about reservations in the common sense and not the international law term, form of the expression, voice those views to the other heads before a decision is taken, as distinct from either abstaining on the decision or going along with the decision, and then after the decision is taken, requesting the opt-out. You wouldn't be able to say much on that.
No, I'm not familiar with the procedure, Mike.
Yeah. Okay.
Where in the treaty does it give you the basis for the suggestion that you just made, that the conference ought to have the flexibility to decide on reciprocity or not? Or are we recreating the treaty as we talk? Because I thought that the wording here should govern the arguments that we're having. So where in this treaty does it give, or expressly or by implication, the conference the competence to impose the notion of reciprocity in relation to opt-out under Article 27.4?
Well, it doesn't expressly state so, but when having read Section 27.4, which started out subject to the agreement, and at the end it conditioned that it must be not prejudice the provisions of the treaty, it suggests to me that the conference can make agreement which would not be contrary to the rules of the treaty. So whatever conditions, they have the flexibility of place conditions in that agreement as to how the opt-out should operate.
But you listened to the submissions of the amicus curiae yesterday, huh? Including Mr. Westman, James. I thought when you started your submissions this morning, you said that you agreed with the amicus.
To the extent that the Article 27.4 is silent as to how the opt-out should operate.
Well, that's a view. That's someone's view. Another view is that it really isn't. My brother here, and there's the common sense wording of it suggests that the opt-out means only that you opt out of obligations, and that is all that the conference can permit. But anyhow, we understand what you're saying, so for what it is worth.
Well, unless I can be of further assistance, those are the submissions.
Okay.
Thank you, Your Honors.
Yes, thank you. Mrs. Brathwaite?
Your Honors, I will not be long, and I certainly won't be taking up all of my minutes. But I just wanted to reinforce a few points that was made yesterday. And first of all, we would just like to state that the principle of reciprocity, in our view, applies to Article 27(4) of the RTC, at least in respect of obligations concerning the rights of establishment and the provision of services which presume of necessity the right of movement of community nationals. Such a view is also posited by the state of Antigua and Barbuda, the UE Mona campus amicus curiae, who unfortunately isn't here today, and the Caribbean community. We also feel that there is no need for there to be an express statement with regard to reciprocity when the conference makes a decision to grant an opt-out to a member state under Article 27(4) of the RTC. Once again, we'd like to stress that the RTC, in our view, is not a humanitarian treaty, and therefore the principle of non-reciprocity does not apply. There is no substantive implication that the principle of non-reciprocity applies to the provisions of the RTC. The member states that have been granted an opt-out are primarily also OECS member states. The OECS provides for the movement of its nationals without any official certificate of recognition under the Revised Treaty of Bastille. And the other point we wanted to just reiterate is that there is insufficient data on which to establish legal precedent that member states who have opted out are still allowed to derive the benefits of the decision from non-opting out member states. And in any event, as was said yesterday, data that would be applicable would be from non-OECS member states. So unless I can assist the court any further, that's the final submissions from the state of Barbados.
So the Barbados, Mona, CARICOM, Antigua and Barbuda consider that opt-outs are reciprocal.
Yes, Mr. President.
You see, I'm sorry, President, but Council, I hear clearly what you have said, but you do not interact at all with the arguments made to the contrary. So if you come and you say, well, my position is so-and-so, that is fine, we understand that. But how do you respond to the arguments that were made yesterday? We suggest that non-reciprocity ought to apply. You haven't responded to them, and therefore if you have not responded to them, what weight do we give to your submissions? I mean, these are arguments in reply, am I right?
Yes,
So you have to reply to the arguments which are against your position.
Well, my Lord, we heard the submissions from the amicus curiae from UE Cable Campus. And when we were dealing with the issue of non-reciprocity, in our written submissions which we filed and in our oral submissions yesterday, we based our position that non-reciprocity is only applicable to humanitarian treaties. And we base this on the fact that when one looks at the terms and provisions in the RTC, and compare it with what would be considered a humanitarian treaty, it can't fall in that category.
Counsel, you are repeating what you said yesterday. I'm asking you if you wish to respond to the arguments that were made to the contrary. In other words, I thought that all three persons who spoke from Cave Hill, and in particular, Dr. Berry and Mr. Westman James, made arguments in favor of non-reciprocity. I'm asking you if you care to respond to those arguments. If you do not, I understand, but I'm just asking you whether you care to respond to those. Have you thought about what they said?
Yes, Your Honor, I thought
respond?
about what they said, but I was of the view that the positions that we had put forward in relation to reciprocity and non-reciprocity would have adequately responded to the challenges they tried to bring yesterday.
Fair enough.
Fair enough. Unless I can be of any further assistance.
Now, as I understand it, the Council for St. Kitts was kind of recognized, acknowledged, I thought, that there is non-reciprocity as a principle in this particular treaty when you look at Articles 7, 8, and 9. Reason why I think she said you have to consider them to be suspended, at least that needs to be said with so many words. Of course, in these opt-outs, there's nobody says that 7, 8, and 9 have been suspended, which would, as was indicated by the learned members of the faculty, that these are core provisions. So it would be very difficult to consider them suspended in one way. But these provisions clearly indicate that there is non-reciprocity in certain limited areas. When we talk about the waivers and in other areas, subsidies, there are some kind of reciprocity mechanisms. But that is also only in limited areas in the treaty. So doesn't that seem to indicate that indeed the main principle is that there is non-reciprocity, only when it is in so many words indicated in the treaty, then there will be reciprocity. Now, that sounds like quite a solid argument to me. So, would you want to react on that? Because what you are saying is, oh no, non-reciprocity, that is something for human rights treaties. That may be so. I believe so, that is so. But who says, which authority says that it is restricted to human rights treaties? I am not aware of that, but if you are, then I would like to know where you get that from. But as far as I know, this treaty in principle is non-reciprocal unless in very narrow areas there is reciprocity dictated. So if you can show us, some authority which says no, non-reciprocity is only in human rights treaties, then I would like to.
Well, in our submissions, we had talked about, Your Honor, Article 60 of the Vienna Convention, which provides for the principle of reciprocity with the exception of provisions relating to the protection of the human person contained in treaties of a humanitarian character, in particular to provisions prohibiting any form of reprisals against persons protected by such treaties. And then we went on to the EEA agreement, where we were showing that that is a community agreement, but it had a lot of tenants dealing with trade, just like RTC, and that was not considered a humanitarian treaty, and therefore we came back to the argument that reciprocity would be the dominant feature as opposed to the default.
Well, the Vienna Convention can say that reciprocity is generally the principle, But then you look at the treaty, and then you ask yourself, does that encompass that principle? And when you look at it, it seems to say no. So that in this treaty, it's the other way around, it seems. But anyway, so what you are saying is, well, given the sources that I mentioned, we do believe that reciprocity is the dominant principle also in this treaty, and therefore we have to interpret these provisions in that vein. That is what you are saying. Yeah.
Yes, Your Honor.
Okay.
Do you share the view of Antigua and Barbuda that the conference has the competence to decide what the consequences of the opt-out will be?
Yes, Your Honor. We do believe that they should be given that flexibility.
So even though you argue for reciprocity, you say the conference itself can decide that there will be no reciprocity?
Yes, Your Honor. The conference, in fact, is made up of the heads of government. And when they meet at the conference, they're representing their nationals, their country. And I believe that they would be well equipped to make the proper and appropriate conditionalities to an opt-out.
So you're saying the treaty requires reciprocity in relation to 27.4?
In relation...
But the heads can overturn that?
In relation to 27.4, that 27.4 is the
opt-out provision.
The opt-out clause.
You're saying that clause requires reciprocity.
That clause requires reciprocity.
Together what you're saying.
Yes.
But in response to the question from my sister, you're saying, if I understand you, that the conference can overturn that and can require non-reciprocity if they wish.
Well, as was submitted yesterday, the conference, before it makes its decision on the opt-out, it needs to look at certain factors and considerations.
Talking about the competence, you're saying that the conference is competent to impose non-reciprocity, even though your reading of 27.4 requires reciprocity. Is that what you're saying?
Yes, Your Honor.
What is not allowing the conference to amend the treaty? And is there not another...
but provided it's not prejudicial to the objectives, I believe the conference may be able to have that flexibility.
Okay.
I've heard that's for the second time today, that the consequences can be determined by the heads once they do not prejudice the fundamental objectives of the community. But I don't see it in 27.4. I don't see that competence of the heads there at all. But this is the second time for the morning that I've heard that statement. How does that work, Ms. Raffis? Where is that power? The agreement of the conference is as to the opting out.
Yes, the conference has the, say, power to decide whether or not an opting out can take place. They also, in our submission, have the ability to place certain conditions. For example, the time period of the opting out, whether or not the member states who have opted out will derive the benefit from the decision. That is something which perhaps the conference can have a discussion on and make a decision on it. Through Article 27.4, it was pointed out that there can be agreements done between the member states outside of the conference area, which could deal with this same issue that's being discussed now. And we already know that the OECS has some sort of an agreement in place amongst its members.
Well, you were saying, yes, the conference, the heads can impose certain conditions on giving the opt-out, but this would seem to be more a condition of the country that wants to opt out. You know, we want to opt out, but you have to leave our citizens. You should give them the right to go to other countries. And I'm not so sure if the conference has that latitude. Now, everybody agrees there needs to be flexibility, because it is important. These decisions usually have to be unanimous. At least there shouldn't be too many who do not vote. So to make a next step, you want nobody to veto, and this opt-out is an instrument of keeping countries from vetoing the decision. So we all understand that. So you need wiggle room, you need negotiating space, as it were. The question is, how far does that go? Anyway, you think this could be part of that, as they nowadays say, this deal.
The deal.
The deal.
The deal.
Okay. Thank you.
Yes? Anything else?
No.
Yeah. Thank you, Mrs. Brathwaite.
Thank you, Your Honors.
Ms. Forrester, are you hearing us?
Yes, Your Honor, I am.
Okay. Are you able now to make your closing remarks?
Yes, I am. Yes, I am.
Yes. You missed it.
Thank you. We just wish to make a few comments with respect to whether the Article 27 procedure relates to obligations and or if it relates to rights. Now, in the most concise manner that I can put it, when a state opts out via Article 27.4, the opting out state is not required to comply with particular obligations. When the conference agrees to that opt-out, what the conference in turn does, that decision affects the rights of members, of nationals of other member states. So in other words, we have one state is not required, the optional state is not required to follow obligations, but the rights of nationals of other states are affected. So for instance, if I was from Barbados, I would not be permitted to go to St. Kitts and Nevis as a security guard because they have opted out of those specific provisions. Now, keeping in mind that that is what actually happens when one state decides to opt out and the conference decides to permit that state to opt out, we submit it as reasonable for the conference to in turn set parameters within which the opting out must take place. Of course, I think the question that was raised recently is, does the conference have that power to impose restrictions of that nature via Article 27.4? And though Article 27.4 does not state that the conference has such a power, the functions of the conference from Article 12, we see it is to determine the policy directions of the community. And one of the key things that the conference does, it makes decisions, which in turn is how the provisions of the RTC are brought into force. It is those very decisions of the conference itself that sets obligations on member states to comply with various aspects of the RTC to bring them to fruition. So in the absence of the conference being able to make these decisions, and Article 27.4 requires it to make a decision in terms of whether or not to opt out, we submit that it is quite viable for them to impose parameters when it determines whether to grant an Article 27 opt-out.
That's it. Is that it?
Your Honor, that's the extent of what I have
Okay.
to say. Yes.
Okay. I wanted your view on this issue, because it's come up this morning. Is there such a qualitative difference between setting a time frame within which an opt-out should last and imposing reciprocity on the opt-out such that one in principle is permissible, the former, but the latter is not? Do you understand the question?
We can probably think of, I wrote it down just in case.
Yeah.
So just one is. Your Honor, I think both are actually permissible and things that can be done via Article 27.4, in that they can, a time frame can be set and the parameters that are imposed can be such that there is no reciprocity when the opt-out is agreed upon. Now, we state that we said more so in the context that the conference, when it decides policy and it is making these decisions to advance the RTC, and member states present challenges or the difficulties in being able to, at the same pace, move on those various decisions that the conference is minded to make, there must be a framework within which those member states who are asking for time or consideration or things of that matter, they should be given that space within which to work. In addition to that, I think that's my response to the question.
Okay. Okay. All right, thank you very much, Ms. Forrester.
Thank you.
Ms. Bullen Thompson.
Good morning, Your Honors.
Yes, good morning.
We would just like to make some brief comments in relation to some of the issues raised, in particular this morning in the reply submissions. Your Honor, in relation to the issue of reciprocity and non-reciprocity, we believe we've addressed this sufficiently already in our submissions, and we continue to rely on paragraph 39 of our submissions, which are found at pages 310 to 311. Your Honor, one question that was raised this morning is about the flexibility of the conference to determine the parameters of the opt-out. Your Honor, we would respectfully submit, having looked at the provisions of Article 12 and Article 27, we do not see there is we do not agree that there is that kind of flexibility. While we would agree that if that flexibility existed, that it would be good, and it would be good in terms of moving the integration process forward and getting states to agree. Having looked at the document, which is the treaty, we do not believe that there is that flexibility in the provisions for the conference to determine that in relation to rights. We understand Article 27(4) to be speaking to obligations.
I want to be clear.
Pardon me?
You don't think that the conference has the flexibility to do what?
We do not believe that the conference have that flexibility to basically indicate that the reciprocity in a way that would strip away rights that are confirmed by a decision.
Okay, so you believe that the non-reciprocity should govern all opt-outs, that the conference cannot impose as a condition for an opt-out that the opting out state can only, cannot enjoy the rights of the agreement.
Your Honor, that is our respectful submission. Your Honor, in relation to that issue, I noted that my learned friend from Grenada spoke to the powers of the conference to direct policy. But policy generally speaks to general direction in where an organization or an entity wants to, the direction they want to go in. And it's not so much, while policy will may eventually determine what rights are granted, policy is totally different from a right. So we do not accept that is a comparison that was helpful on this occasion. Your Honor, one of the issues that, well, I wouldn't so much call it an issue, but one of the points that has been raised continuously through this hearing is the opt-outs that have already been granted. And I know the court has expressed a view that, why are you coming? These opt-outs have already been granted. That question was asked. Your Honor, in regard to those opt-outs, I remember that the court may have asked, and I stand corrected if my recollection is not correct. I was trying to find it on the live feed, but I couldn't. That may have asked Ms. Bob Schaefer, counsel for CARICOM, whether there should be any comment on the opt-outs that had already been granted. Your Honor, in relation to that matter and how the court should treat that with the opt-outs that have already been granted, Your Honor, we respectfully say, or we respectfully submit that the court should be cautious in commenting or addressing the opt-outs that have already been granted. Your Honor, we say this simply from the point of view that it is possible that those opt-outs may become in the future the subject of litigation that can possibly come before this court. Your Honor, we would respectfully say that for the purposes of this hearing, that the court can indicate what the position is on the law, and if anything, if it can see from its conclusions and from the advisory opinion issued that there may be some need for those opt-outs that have been granted before to be addressed, that the court can, without giving specific opinions on the opt-outs that have gone before, simply indicate in its advisory opinion that it recommends that those decisions be looked at again. So, Your Honor, those were our views in relation to what should happen, Your Honor.
Thank you for raising that. That's very interesting. I think our rules might have something to say, or OJ rules.
Yes, please.
On the relationship between advisory opinions and contentious matters. Have you consulted the rules on that point?
Your Honor, I did take a look at the rules. I did take a look at the rules in relation to the original jurisdiction, and I saw there were some procedural rules. I did not see a specific rule that is akin to what is stated in, for instance, the European Convention in relation to human rights. There is a specific rule, there is a specific provision in their convention which says that the court should not consider or give opinions in relation to matters that were likely to come before them. I did not see a similar provision in the rules of the CCJ. Unless there are any other questions, those would be the submissions of St. Kitts and Nevis.
Thank you very much, Ms. Bullen-Thompson. Dr. Bob Schaefer.
May it please this honorable court. The heights that great men reached and kept were not attained by sudden flight, but they, while their learned friends slept, were toiling upwards in the night.
What does that reply to, Mrs. Babshafer?
I'm going to...
What argument presented yesterday does that respond to?
Yes. So I have the answer. I have the answer, having examined all the pieces of the puzzle. And I would say, Your Honor, that all of us, my learned friends and the court, all had a correct piece of the puzzle. I'd like to respectfully submit that I know how to fit this puzzle together. But before I do that, Your Honor, I would like to refer to, just to clarify, a question raised by Your Honor yesterday. Yesterday, Your Honor said, in response to my learned friend from Barbados referring to a 2006 decision, can we use precedents where participants do not regard them as legally binding? And I would like to clarify that the request for the advisory opinion should not be understood as the conference not regarding the previous decisions as legally binding. As Your Honors are aware, although the conference remains the supreme organ of the community and the member states are the same, the heads at the table change, and the legal advisors change, and the institutional memory is not always present. The conference is of the view that on balance, it acted lawfully, but for legal certainty, this matter is before this honorable court. Yesterday, the honorable court indicated that Article 27.4 is concerned with a member state opting out of obligations. This is absolutely correct, but this is not the end of the matter. Article 27.4 is broad in scope. It is not found in Chapter 3 of the Revised Treaty, which is concerned with the right of establishment, the right to provide services, the right to move capital, and the movement of community nationals. Article 27.4 is found in Chapter 2, which deals with institutional arrangements and is found under the heading of common voting procedures. As Article 27.4 is broad in scope, not all opt-outs require the application of the principle of reciprocity, and by extension, the application of Articles 7, 8, and 9 of the Revised Treaty in order to achieve commutative justice. So, for example, an opt-out in relation to a decision...
So just to be clear what you're saying that not all opt-outs require the application of reciprocity. Is that what you're saying?
Yes, require the application of the principle of reciprocity.
You're saying then that some opt-outs can, in fact, be made on the basis of non-reciprocity?
Yes, Your Honor.
Very well, okay.
So, for example, an opt-out in relation to a decision that member states shall carry out national consultations on a particular matter by a defined period does not require a suspension of Articles 7, 8, and 9. The opt-out is the end of the matter. There's no need to go further. The answer to the specific requests lies, as I've indicated, in a combination of all of our submissions, as well as initial indications expressed by the court.
So you're going to give us a very clear test which we can apply to indicate which opt-outs require reciprocity and which do not. Yes?
We'll see, Your Honor.
You don't know what's in the notes?
Well, the way that I've done it we might not need to do that, but I will do my best to address.
Yeah, I don't want to think, but you see, you have said that some require reciprocity and others do not.
Yes.
So I'm asking you, what is a touchstone by which we decide which require and which does not?
Well, there
is that not a fair question?
Yes, Your Honor. There is a need, not only in relation to the WTO agreement, but also in relation to the Revised Treaty of Chaguaramas, to balance the rights and obligations of member states. And an instance where an obligation is going to affect the rights of nationals of member states, as Grenada have pointed out, the conference may have to, as it did, and we respectfully submit, lawfully did in 2006 when it suspended the operation of Article 7, 8, and 9.
Are you saying then that in deciding what the touchstone is, we should have recourse to the WTO rules?
No, we don't. There's no need for the...
Mention the WTO, because I thought the WTO, in allowing the existence of the RTC, gave us a carve-out within which we could operate our rules.
Not in that sense, Your Honor.
Right.
In the sense that in negotiations, it is always important to try to balance rights and obligations. And in WTO negotiations, member states often refer to the fact there's a need to balance the rights and obligations. So, for example, in the schedules, if you want to change the bound rate in relation to particular goods, member states may be looking to see, well, what are you going to give
Well,
in return?
It's not just WTO. I think it's just general, that if you are making a contract or making a deal, then you balance rights and obligations. But surely, the competence to balance the rights and the obligations must be conditioned by the legal environment in which you're doing just that. Now,
Absolutely,
the
Your
legal
Honor.
environment is described.
Absolutely, Your Honor.
Article 27.4.
Yes, absolutely, Your Honor.
Right,
There's
okay.
no conflict.
Right.
Okay. So the rights which member states have where an opt-out is granted to another member state depends on the subject matter of the decision. So you have to look to see what is this decision concerned about. So the rights differ if the opt-out relates to conducting national consultations, as opposed to an opt-out with respect to Article 46 conference decisions on the enlargement of classes. The legal effect of each opt-out must be determined on its own facts. In the absence of express provisions indicating the effect of an opt-out, the conference requires flexibility to determine the appropriate legal effect where a member state is to be granted an opt-out.
How do you respond to the point made yesterday that the way that the conference can exercise that objective is to allow opt-outs by other member states who do not wish to operate on the basis of non-reciprocity? I thought it was a very good point made yesterday. How do you respond to that?
Well, I'm going to refer to two provisions by analogy. One in Article 48.5, and the other in relation to one of the accession agreements pursuant to the Treaty of the EU Treaty of Accession 2003, where there's a provision in there to deal with derogations granted with respect to with respect to workers, with respect to movement of workers.
And is that provision worded in the same way as 27.4?
Well, 27.4 is not worded in exactly the same way, but 27.4, as I've indicated, is found in the chapter dealing with institutional arrangements. So it's just this broad power. It is not directly linked to chapter 3. It is a broad power that the conference has to agree to a member state opting out of decisions provided they do not.
Opting out of the obligations.
Opting out of the obligations of a decision, but you don't opt out of rights. So opting out of an obligation of decisions provided that they do not prejudice the fundamental objectives of the community. So if I may then turn first to Article 48.5, and I think that Article 48.5 is instructive for the court to see that in Chapter 3, with a provision dealing with waivers, their opt-outs are waivers, they're derogations. In Article 48.5, it is provided a member state which has been granted a waiver shall not, while the waiver is in force, be entitled to espouse a claim on behalf of its nationals against another member state in respect of the rights for which the waiver was granted.
Would you say that that wording is different from the wording in 27.4?
The wording is different, but 27.4, in fact, a fortiori, language such of this should be implied into the revised treaty to enable the conference to balance the rights and obligations of member states. And it is not illegal because
Sorry, you have answered yes to my first question, that the wording is different. My second question is, do you think that the framers
Sorry, Your Honor.
Do you think that the framers of the treaty could have included wording similar to Article 48, Paragraph 5 in relation to 27.4?
Your Honor, well, of course.
Yes.
But similarly,
and they did not.
But similarly, the framers of the Revised Treaty of Chaguaramas could have put a provision here that Quartet has the power to classify goods. But the mere absence of an express power, as Your Honor is fully aware, does not mean the power doesn't exist. As Your Honor is aware, applying the implied powers doctrine, an international organization has all the powers necessary to enable it to carry out its functions.
And I thought one of the points of the arguments made yesterday was that the implication for which you are fighting so hard is not necessary for the conference to carry out its functions. I thought a point made, and you haven't yet responded to it, is that one way in which the conference could allow for the operation of quote-unquote reciprocity would be to allow opt-out by those member states who do not want the application of non-reciprocity in relation to the decision taken. And if the conference does that, and I think both Cave Hill and the Federation of St. Kitts Nevis were making that point in different ways, if the conference did that, it would achieve the objective that you speak of, and it will be consistent with the wording of 27.4. So we don't have to go and imply a whole new regime in order to achieve the objective for which you are fighting. It can be achieved within the corners of what is written here in 27.4.
Apologies, Your Honor. Can you please repeat?
No, I thought I was trying to say that the objective of trying to make sure that the opt-out is reciprocal, that objective can be achieved by allowing those states who do not wish for non-reciprocity to apply to seek and obtain an opt-out from the conference.
Oh, so those states themselves would not have to apply for an opt-out. I'm going to suggest a formulation.
No, I thought that, unless, and of course, the council is here, so they can correct me if I'm wrong, but I thought that is what was being suggested yesterday. Now, that would be faithful to the regime which we have in 27.4.
So the answer would be that the other member states would apply for an opt-out.
Yes.
Oh, I think I have it would have the same legal effect, but I
And
think
the
I have a
advantage it
different
would have is that
approach.
it would be faithful to the wording of the treaty.
I didn't get that there. All right, that will come back. Okay, so I would now like to turn, okay, so before I leave 48.5, and I urge this honorable court to look at 48.5 because it deals with chapter 3. Although the first paragraph of paragraph 30 says it deals with right of establishment and it doesn't specifically mention movement of capital, the chapter itself, not only the preamble, but the substance of it shows that it also deals with movement of persons. And in relation to waivers of obligations to grant rights, it is clear in Article 48.5 that the solution was to prevent the member state obtaining the waiver from exposing a claim on behalf of its nationals against another member state in respect of the rights for which the waiver was granted. And it is respectfully submitted that the position with respect to opt-outs in relation to Article 46 enlargement decisions ought to be the same. That is a position that is fundamentally fair and balances the rights and obligations of member states. Thus, a member state which has been granted an opt-out shall not, while the opt-out is in force, be entitled to espouse a claim on behalf of its nationals against another member state in respect of the classes of persons for which the opt-out was granted. It would have been impossible under 27.4 to put down all the possible scenarios that would arise and how they would be dealt with. But it would have been better if the clause was repeated and the legal effect was stated. But that hasn't happened, but it's not fatal. The fact that it is not expressed does not mean that it cannot be implied. This approach, if we adopt this approach, it leaves it open for member states to allow agricultural workers, security guards, or whichever class of persons is the subject matter of the decision to move and work freely in the community. And there will be no need for any bilateral agreements, which was a concern of the courts. So just to be clear, what is being said is that if a similar provision is implied in relation to another Chapter 3 matter dealing with another right, a similar right, the effect would be that the member state will not have the right to expose a claim on behalf of its nationals. But that in itself doesn't mean that the nationals cannot go over there, go to another member state and work. So there's no need for any bilateral arrangements. In addition, the approach of applying the principle of reciprocity, and we say here is the default position, so applying it where appropriate, is consistent with the Treaty of Accession 2003. This is this EU treaty, which was concerned with 10 Eastern European countries seeking to accede to EU treaties. Now, the treaty allowed the existing EU members, to derogate from the provisions concerning movement of workers of these new categories. Workers from these 10 Eastern European member states who wanted to accede to the EU treaties. An individual accession treaties were done. A provision was made for derogations both ways. So here we see, this is the accession agreement with Croatia, but there's also one with Poland, and Poland actually enforced the reciprocal mechanism. So by way of derogation from Articles 1 to 6 of regulation, that the present member states, so those were the existing EU members at that time, before the others joined, will apply national measures or those resulting from bilateral agreements regulating access to their label markets by Croatian nationals. The present member states may continue to apply such measures until the end of the 5-year period following the date of accession. And there's 5 and 7, but I just would like to go to 10 in the interest of time. And condition 10 says, whenever national measures or those resulting from bilateral agreements are applied by the present member states by virtue of the transitional provisions, Croatia may maintain in force equivalent measures with regard to the nationals of the member state or member states in question. A provision like this does justice. It is fundamentally fair that if one member state has received a derogation, that the other also receive a derogation. And I understand, but I didn't have enough time last night to get the position, some legal authority with respect to Poland. But my understanding is that with respect to Poland, when Germany derogated with respect to the Eastern European workers, that Poland decided to enforce equivalent measures. So what I'm saying, in essence, therefore, is that in fashioning the advisory opinion, the court ought to, and I'm saying this respectfully, take into account a provision like this, a provision like in 48.5, which is actually dealing with Chapter 3 matters. And so the position is not exactly like how we set out in our submissions yesterday. Yesterday, I'd indicated in the submissions that the effect would be to exclude 7, 8, and 9. But on greater reflection last night, and recognizing that opt-outs are different, there's no automaticity. There cannot be any automaticity there. Neither can there be a hard and fast rule in the way that has been advanced, that there's an opt-out and the hands of the conference are tied, and therefore it doesn't matter whether it's fair or not. A member state can have his cake and eat it.
Well, there can't be an opt-out unless the conference agrees.
Well, and what's going to happen then is more...
Do you agree with that?
Yes.
So why do you say the hands of the conference are tied?
Well, in fact, we probably wouldn't even reach the conference because the decision would be vetoed. Well, it may come up in the conference, but the decision would be vetoed, because if a member state is of the view that what is happening is fundamentally unfair, they're not going to agree to the decision in the first place, and that's not going to advance the regional integration movement. So we have...
They will agree to a decision that is fundamentally unfair if they can impose the same unfairness on the other member state.
If they can impose...
Unfairness on the member state.
Well, it wouldn't be unfair.
Oh, so two unfairness equals...
So, in essence, this court has often taken the approach that it must adopt a theological approach. You interpret the treaty in a manner to render it effective. This applies also in this circumstance. There's Article 48.5 indicating that in relation to Chapter 3 matters, and these are waivers before the Community Council.
Yeah, but with respect, General Counsel, as you know, the waivers regime is very different from the opt-out regime. And if you read the provisions of the Article 48, it will be very clear that that is so, okay? So with respect, I'm not sure we can move directly from 48 to 27. They're very different regimes altogether. I understand that you're trying to make the analogy, but I'm just saying, please, don't move directly from 48 to 27, because if you read them, you see they're very, very, very different.
Yes, that's because 27 is separate. It covers the whole scope. But what the argument that's being made, the link between the two, is that the obligations aren't being applied. It doesn't matter whether you call it an opt-out under Article 27 or you call it a waiver under Article 48.5, the effect is the same. So what I'm saying, 48.5 is instructive because it shows in the context of Chapter 3 matters that reciprocity is desirable. So although there is no provision, a similar provision with 27.5 with the word opt-out, it doesn't mean that such a provision should not be applied. So if I may just sum up. So in
sorry, do we have this case that you mentioned just now? The one on the screen?
I have part of it. The document's like 289 pages, so I couldn't print all.
Well, if you just give us the reference.
Yes, so it is the Treaty of Accession, 2003. And the individual accession agreements with any of the 10 Eastern European states would contain the similar provision. And well, the one that I'm presenting here before the court is the one with Croatia.
Mm-hmm.
Okay, so in conclusion, the nuanced submission of the Caribbean community is this. 1, free movement of community nationals is a fundamental objective of the community. 2, an agreement of the conference to grant a member state an opt-out with respect to Article 46 decision to enlarge the classes of persons entitled to move and work freely in the community is not ipso facto ultra vires. Each case must be determined on its own facts. Factors such as the imposition of a time period are relevant. 3, where an opt-out is granted with respect to an Article 46 decision concerning the enlargement of classes entitled to move and work freely within the community. 1, and this is the Croatian clause modified, member states may maintain in force an equivalent measure with regard to the nationals of the member state or member states in question. So with language like they may maintain in force means that you don't need bilateral agreements. They don't have to, but they can, like Poland with respect to Germany, but they don't have to. And 2, a member state, and this is now the 48.5 formulation, a member state which has been granted an opt-out shall not, while the opt-out is in force, be entitled to espouse a claim on behalf of its nationals against another member state in respect of the classes of persons for which the opt-out was granted. And with all due respect, this formulation or this approach to the matter addresses the concerns of the amicus curiae with regards to the proliferation of bilateral agreements. There's no need. So that has been addressed. In fact, I think all concerns have been addressed. The conference would also have flexibility to determine on a case-by-case basis if there's a need to balance rights and obligations, or if the status quo remains apart from the opt-out. So unless you're...
Wait. I want to be able to understand you perfectly well. You're saying that reciprocity is fundamental to Article 27.4, that the conference, that's not what you're saying?
No, I'm not saying that it is fundamental. I'm saying each decision and the application for each opt-out must be determined on its own facts. Because some decisions don't require...
The conference is entitled to say in a particular case that in this particular case, the arrangement will be on a non-reciprocal basis.
Right, but it may not have to say so expressly, because if using the example I'd given, the decision was a quoted decision that member states should conduct national consultations by the 27th of October, and the member state left from quoted and went to the conference, and the conference agreed, there's no need to do anything, because it doesn't really affect.
Each state has the competence and the right to determine for itself whether it will treat with the opting out state on a reciprocal or a non-reciprocal basis.
In essence, but in some instances, reciprocity is just not relevant, because like one with national consultation, there are many decisions under Article 27.4, possibly, where nothing needs to be done, because it just means that that member state may not filing documents. That doesn't have any, serious consequences.
But I'm trying to understand how this works. How do members of the community know? Because everybody has an interest in knowing.
Yes.
Which countries are going to permit persons of a particular class and which countries are not.
Okay.
So how does that work?
So if in relation to Article 27, in relation to the 27.4 as it relates to the enlargement of classes of persons, because I can't just say Article 27.4 simpliciter, because one size doesn't fit all. So if in relation to another Article 46 decision, the heads were to say, member states may maintain and enforce an equivalent measure with regard to the nationals of the member state or member state in questions. They may. Then they know that they can. And if the advisory opinion states so, well, the authority is there. The problem is before that there's no, it wasn't explicit in here. All there was a decision, I don't even think it was before the conference, was that decision in 2006 where Article 7, 8, and 9 were suspended. But if you have a clause like this, and that reminds me, yesterday, Mr. Justice Witt had raised the question about, why was there need to suspend 7, 8, and 9? If it is phrased like this, there's no need to have any explicit reference, especially if you have an authority, because the only member states only want to know what they're doing is correct. So if they could point and say, well, implicit is, that when an opt-out is granted with respect to classes of persons, member states may maintain and enforce an equivalent measure with regard to the nationals. That's the end of the matter. They may or may not.
Okay, they may or they may not. So what? They write to the Secretariat indicating that on this particular occasion, we are going to maintain similar measures.
They may do like Poland. I hate to, I don't have an authority here that I understand, and understand that you declare. Once you have the power, you declare and you notify. So they would notify the conference. Sorry? Oh, so my learned friend is here reminding me of Article 227 wherein this treaty provision is made for notification to an organ. But if it is not explicit like that, or the conference could say that, the conference could agree that in an instance like this, there be notification. So what would happen is that if one member state has a difficulty with it because they don't think that it is fair, they could still allow the opt-out. We can still have a decision, but they would decide that they will not be taking workers from that particular country. And then we don't need any.
But those words may, that the other countries may take these measures, that must be then part of the opt-out text. And what if that is not in the text?
Well, if it is in the advisory opinion, it doesn't have to be in the text. If it is known, if it is understood, it would be good if it is in the text. Because if it is in the text explicitly, it provides legal certainty. Then one doesn't have to go and look and see what the advisory opinion said or try to do their own analysis of what all these provisions mean.
Okay, so this is the puzzle?
Yes, all put together, all parts of every submission made here, all parts of indications for the bench seeking to address concerns of bilateralist proliferation of bilateral agreements.
I must say I'm still a little puzzled, but we will try our best.
Thank you very much. So unless, any further questions? So thank you, much obliged to the court. Unless your honors wish to hear me further, these are the submissions in reply of the Caribbean community.
Yes, thank you.
Okay.
Dr. Berry, these are not contentious proceedings. Do you wish to say anything? If you wish to, we give you a little time.
Yes, Your Honor. May I consult with the co-counsel?
Yes.
You're talking to one of them.
Your Honors?
Yes, sir.
Thank you. I cannot promise to put together puzzles and for us, but I have a few points arising in response to what was said earlier. First, I understand that the acceptance by CARICOM that reciprocity is not the default position would change the nature of all of the submissions. I am concerned with use by CARICOM of the accession treaty as a kind of model or example, because the accession treaty is a treaty and it's negotiated in the same way that any treaty would be negotiated with reservations, etc. With respect to...
Couldn't the opt-out also not be negotiated?
Well, opt-outs are negotiated, but again, my point yesterday was that opt-outs are in the context where you have already become part of this organic institution which is developing and ever progressing. With respect to the use of Article 48, CARICOM conceded that Article 48 does not apply by its terms to free movement of persons. Article 48 refers to Article 30. Article 30 applies to various forms of freedom, but not free movement of persons. So again, I'm not sure of the helpfulness of that. With respect to the puzzle that she has brilliantly put together, like one of your honors, I'm not sure I can see the puzzle so clearly yet, but it seems to me that the solution of having the opt-out of Article 46 with members being able to, may maintain, enforce equivalent measures in a kind of non-reciprocal way, that doesn't gel with me with the discussion yesterday. The discussion yesterday was, does Article 27, subsection 4, apply only to obligations, not rights? Now, if that is the solution, if it applies only to obligations, then that resolves it. But if rights may or may not be derogated from, it appears to me that that gives rise to tremendous uncertainty and tremendous practical uncertainty for individuals. So an individual, we gave the fictional the example of an Antigua and Barbuda national traveling to, say, Barbados, where an opt-out has been asked for and been given to that state. If the conference says, even in the text of the decision, states may accord these rights to nationals, what happens to the national from Antigua and Barbuda where Barbados has said, we will, say they formally codify it in the decision, we will extend in a non-reciprocal way, but then Barbados has a change of government and they say, well, actually, we're not going to extend it, and this national has gotten on a boat or a plane and ends up in Barbados and arrives at immigration and has problems accordingly. So I think that kind of discretionary approach is a little less satisfactory. And the idea that member states not being able to bring claims, I mean, that resolves some issues on behalf of their nationals. But again, I would prefer, or our submission is to prefer a non-reciprocal regime, is clearer, simpler, and more practically efficacious. My colleagues gave me other brilliant submissions, but unfortunately they have left like winged birds from my mind, so I cannot provide you with those. If I can be of any further assistance?
Thank you.
Yes, thank you.
Much obliged.
Well, I wish to thank all council for their efforts, their submissions. We are going to consider all of them, of course, and I wouldn't be able to give you a time now when we would give the decision, but I could tell you that it would be given within a reasonable time. Unless there's anything else, then thank you. That's it.
Rise.